Well, good afternoon and welcome to the latest in the King's Chamber's cost seminars. I'm delighted to say that today I'm joined by Stephen Turner. Stephen is a very eminent barrister. He's also been a good friend and an opponent of mine for the thick end of 30 years. And so it's a real pleasure to have him today in order to take part in this non-party costs orders seminar that we've decided to put on for you. The format, for those of you who have watched us fairly regularly, will be pretty familiar. We're going to have a sort of talking heads where we go through an overview of the law and practice relating to the topic, in this case, non-party costs orders. The video is going to be recorded so that you'll have an opportunity if you want to watch it on YouTube later on. And we don't use slides, but slides will be sent out after the webinar so that people have got the references on the cases that we talk about. So in terms of what we're going to look at today, well, there's a lot to get through. And we're going to start by looking at the jurisdiction to make a non-party costs order, some conceptual problems which relate to them, and then the key principles which govern all sorts of non-party costs orders which can be made in numerous contexts. We'll be looking at some key case law, and then we'll be moving on to consider particular contexts in which non-party costs orders might be made, including against funders, insurance companies, credit hire companies, credit hire being the gift that always keeps giving, and looking at the position of solicitors, experts and directors too. So quite a lot to get through today. As always, we welcome questions put into the Q&A or possibly the chat box, and we'll do our best to sweep those up as we get through the topics. But let's start at the beginning. A non-party costs order is simply that. It is a situation where one or other of the litigants to a contested piece of litigation, the parties, decides to seek a costs order against someone who's not a party and not joined to the proceedings. They might want to do that for various reasons, but the court's jurisdiction to make such an order has been well established for many, many years. It flows from Section 51 of the Senior Courts Act. It's found further elaborated in Part 46 of the Civil Procedure Rules. And although the jurisdiction can arise at any point in a case, it's usually used at the end of a case, ideally before the trial judge who will have decided the case, but it need not be before the trial judge and certainly won't be if someone makes an application for one of these orders after a settlement or discontinuance. Having said that, and noting the potential practicality of a non-party costs order, because they can be deployed in many, many different contexts, one has to start with the fact that they're a bit of an odd creature. And the reason I say odd is because if you think about it, we do not have in this jurisdiction any concept of non-party damages judgments, due not least to the presence of the concept of limited liability. But we're prepared, as part of our legal system, to make non-parties subject to the costs of proceedings that they've not been joined to. And this sort of concept of non-party costs orders has been recognised at the highest level as being a bit of an oddity. One of the cases that was decided in recent years is that of Preston Petrodel, which was a Supreme Court decision, where they grappled with this issue of limited liability and the circumstances in which it can be set aside or pierced. But non-party costs orders remain an important exception to the principle of limited liability, and as we'll see, are something which are possibly going to increase in the future for various reasons.
I think, Andrew, if I could just come in there on that.
Say, Stephen, what would you add to that?
What I'd add is you just need to look at Section 51.3. You couldn't get a wider jurisdiction when you go to the primary legislation. The court shall have full power to determine by whom and to what extent the costs are to be paid. So everything else is essentially a gloss on that. But we really are dealing with an extremely wide discretionary jurisdiction that has allowed courts in different spheres, as we'll look at, to pretty much achieve the result they've wanted to achieve, shall we say, by widening goals, narrowing goals, as they seem fit over time. So just bear in mind, this really is the widest of jurisdictions.
And I think Stephen's point is well made, and it finds reflection in the case law. Now, Philip Larkin famously observed that sex began in 1963, and so I can say with a degree of confidence that modern authority on non-party cost orders began in 2004, when the Privy Council decided a case called Dymock's Franchise Systems and Todd. And this is the Privy Council sitting on appeals from the Southern Hemisphere, New Zealand, as I recollect, and deciding cases which had come to them from overseas, but a Privy Council constituted of the Law Lords, who sit in the House of Lords in England and Wales and Scotland. So what they had to say, although not technically binding upon the courts of England and Wales, because of who said it, has always been taken as being a definitive statement of the law. Moreover, this case has been built upon, like layers in a coral reef, by successive Court of Appeal judgments which have accepted the principles that it sets out. And those principles can be stated quite simply. The first point is that although these are exceptional orders, that doesn't mean that there's a particularly high bar. It just means that they're out of the norm, fairly unusual, set against the vast mass of litigation with its ordinary cost orders. Secondly, that there, by and large, is a principle that non-party costs won't be ordered against someone who is a pure funder, by which it might mean someone who is crowdfunding or charitably donating to someone's legal costs to enable them to get access to justice. Most importantly, the touchstones for liability for a non-party costs order were found to be funding and or control and or benefit. And although those are short words, the concepts that they encompass are not easy ones, as we'll see when we look at some of the judgments. And it also emphasised the concept that in order to make a costs order against someone who is not a party, you had to be able to say that they were in fact a real party in all but name to the proceedings. The Privy Council also took the view that causation of costs had a role to play in whether an order should be made or not, and emphasised the difficulty that liquidators and directors might face, and the courts in turn might face, in deciding whether to make a non-party costs orders against them. But in overview, everything in a sense will flow back to these principles. Stephen, what would you add to that?
Each one of those building blocks that you'd have in a non-party costs argument seems pretty straightforward when you mention it. Funding, control, benefit, causation. Let's take some basic examples. Well, if you fund a claim, then you should be in the frame for a non-party costs order. But what about intergroup, cross-company funding? Where does the law stand with that? You've got a layer of complication there. Control, does it have to be active control? Or is it enough that there's passive control? In other words, a contractual risk that something might happen to the claimant if the claimant doesn't act in a certain way. Benefits, well, do credit hire companies benefit? I mean, that's the obvious example from practice area that you and I have done quite a bit of over the years against each other, Andrew. Do credit hire companies benefit? There are very strong views on that either way. Causation, again, do you need causation? Do you not? These are real, potentially difficult questions, very susceptible to the particular factual scenario that you're looking at, and quite often difficult to predict because of that extremely wide discretion that we have. But I think, Andrew, it would be fair to say that the Deutsche Bank case, in a way, came to the rescue in terms of, frankly, just throwing everything out of the window in terms of prior authority.
You could say that. On one hand, you could say it came to the rescue. On the other hand, you could say it set the cat amongst the pigeons because of the approach that it took. And the case that Stephen's just mentioned, Deutsche Bank and Sebastian Holdings and Mr. Vick, decided in 2016 by the Court of Appeal, said don't get too het up on these principles, as expressed not only in the Dimmock's franchise case, but many, many cases between 2004 and 2016. There's too much law, effectively, on this area. What matters, ultimately, is it just to make a non-party cost order against someone, irrespective of how you get there? Now, the problem with that is that in the case of Deutsche Bank, it was a relatively straightforward factual situation where you had a limited liability company and an individual who was the alter ego of the limited liability company. And because the litigation had been promulgated for his benefit through the device of the company, it was a relatively straightforward case to run. Where you get the subtleties in the wider world, Deutsche Bank can create problems because it introduces uncertainty into the question as to whether an order is going to be made in any given context. And lawyers, of course, like certainty, but of course the justice system needs certainty, as otherwise cases will fight which should settle or perhaps should never have been brought. So we have the death of a formulaic approach, but Deutsche Bank isn't the only problem that has arisen in looking at the way you apply these principles. Stephen, can you add something more on causation?
Causation is particularly difficult. If you look at something like Goodwood Recoveries and Breen, that was 2006 Court of Appeal. We had a company director there conducting litigation for his own benefit. Costs were caused by his dishonesty and his impropriety. And the question arose as to, well, do you need causation? Is it sufficient that there's a contributory cause? Does it have to be the effective cause or a but-for cause? And the Court of Appeal helpfully said, well, it doesn't actually matter. He's on the hook for the lot because he's acted improperly and with impropriety, and they found dishonesty in that case. So it just shows that this causation issue is out there. And what touchstone, what test are you going to use for causation? Because if you look at the Travellers Insurance case, well, the insurers funding the litigation, they've caused the cost. But the Supreme Court said no, because an insurer may be funding the litigation, but they didn't cause the cost because they had to fund the litigation. They were contractually obliged to do so. They weren't volunteers. They weren't intermeddling. And so you get another distinction drawn there on causation between those who have benefit from the litigation in a pure form and those who are intermeddling, volunteers effectively. And no simple answer, Andrew, is the point. All fact sensitive, complex on the authorities, complex on the facts, potentially.
Yeah, I agree, Stephen. I think the Travellers Insurance case, which is the Supreme Court decision of 5 years ago now, is one of the most important authorities in the non-party costs area. And I think there are 2 points which flow from it, which are of particular significance when considering causation. The first point is that causation, if it's a strict test, a high test of causation, is possibly the best defence that anyone's got to a non-party costs order. And so what somebody resisting a non-party costs order is going to use is going to focus on those statements of principle which emphasise the importance of causation, and also that it's going to be but-for causation as being the highest bar for the applicant to get over. The second point, however, is that coming back to this theme of ambiguity and jumbled case law and lack of distinction, there's a real difference of opinion by certain judges in certain cases as to whether the statements on the application of causation in Travellers Insurance are actually generic to all species of non-party costs orders, or whether they're limited to non-party costs orders concerning insurance companies. So that in itself raises yet further questions to anyone who's dabbling their toes in this area. So that's an overview then, in the first 15 minutes, of the basic principles. Let's go on to consider how these principles can be applied in real life. And I should say that you've all been very good. We've got about 500 of you online at the moment, but nobody has put their head above the parapet to ask a question. And yet I'm sure that there are people with questions out there. So do not be afraid to put them forward in the chat box or the Q&A, and we'll do our best to answer them as we go along. But what I would like to turn to now is the question of non-party cost orders against funders. And when you use the word funder, it becomes something of a term of art in this context. And the reason is that you have what are called pure funders, and then you have commercial funders. In relation to pure funders, these are the people who donate to someone's legal cost, perhaps for charitable reasons, perhaps for other reasons, but in any event aren't taking a benefit or show no interest in having any control over the litigation. And crowdfunding of, for example, environmental challenges by way of judicial review is quite a good example of people who contribute to others' legal costs for fairly remote benefit to them, if any. And they are never in the firing line for a non-party costs order. Commercial funders, however, are those who operate in the mainstream litigation funding case. And in particular terms, they will be the large third-party funders who will put up millions to promote a case through the courts, who at the end of the case, if it's successful, will expect to get back a multiple of the damages, a multiple of the sums they've advanced by way of costs. And in consequence, because they're in effect underwriting the litigation for their own commercial benefit, fall within the scope of a non-party costs order. Now, for many years, litigation funders had the shield of what was called the Arkin cap. And the Arkin cap flowed from the case of that name and was the idea that if somebody advanced £2 million of litigation funding, then the limit of the costs that they might be liable to pay to the other side who won the litigation against their funded client would also be £2 million. But the Arkin cap was never a principle of law. It was really a sort of convenient stop, if you like, or point of practice as to how the court would exercise its discretion. And there was no basis for saying that in no circumstances would a funder's liability ever top the Arkin cap. A few years ago, there was a case called Chapelgate, which went all the way to the Court of Appeal, who confirmed that the Arkin cap was not written in stone. It could be dispensed with. And in circumstances where you could show that the provision of, say, £2 million worth of seed money by way of funding meant somebody could bring a case that caused somebody else to incur £5 million worth of cost defending it, meant that there was no reason in rhyme, law or logic as to why they should benefit from a protection of 3 million quid's worth of cost that might have been avoided otherwise. And one can also see in here echoes of the same concerns or principles which lie behind issues of causation. What exactly has been the role of the non-party, and in effect, how much damage have they done to the other side through their involvement in the litigation? Now, I'm pleased to say that we're starting to get questions coming through, including what are the key factors that a court considers when determining whether to award costs against a non-party in litigation, and also what specific legal tests or precedents must be satisfied for a successful application for non-party costs under CPR 44.16, and do they vary depending on whether the non-party is a funder of the litigation or someone providing a different kind of support? Well, I'll just have a quick go at that, because in essence I would simply recap what we've discussed in the opening minutes of this. which is essentially that what you're looking for are reasons why it's just to impose a non-party costs order on someone, or if you're defending, reasons why it would be unjust. And in that mix, you will have elements such as funding. Is somebody trying to make a profit out of the litigation? Are they going to benefit from it financially because they have a stake, which may not be a direct interest, but some sort of mirrored interest in the outcome of the litigation? Or are they up to their neck in controlling it so that they are the ones calling the shots, whether in whole or in part? Because the concept of a real party, which again underlies this, doesn't mean you have to be the real party. You can just be a real party. But what would you add to that, Stephen?
In bullet point form, funding has the non-party funded, control has the non-party controlled, benefit has the non-party benefited, and causation, did the non-party's conduct cause costs to be incurred. But the important point to note is that that is not an exhaustive list. You can rely on anything you can think of that you might think adds to the justice of your case. It's as I've said, absolutely unfettered discretion. The simple, immutable, I think is the expression used in one of the cases, Andrew. The immutable principle is that the discretion is exercised justly. Beyond that, really, pretty much everything's up for grabs. But those four key words, funding, control, benefit, causation, I think they're the main ones that we usually see dealt with in skeleton arguments and authorities.
Yeah. And I think the one I would add to that, because it does feature in the case law, is giving a warning to the non-party. Often a warning will have no weight whatsoever, because the party saying they weren't given a warning would have ignored it anyway, in all probability. But there have been cases where someone who's not been given a warning and who may simply be a director of a one-man band company and who didn't appreciate that his actions put him at risk, that could be quite significant in defending the non-party cost application which might follow.
I think that also overlaps with 46.2, which we didn't actually deal with in detail at the beginning, but very briefly, your trial judge isn't just going to make a non-party costs order. Under CPR 46.2, the non-party has to be added as a party for the purposes of costs only, and the non-party has to be given the opportunity to be heard at a hearing. Now, if you've given notice, it might be you can roll all that up into one, but generally speaking, it means you're going off to a different day to have a separate argument. And of course, there's a real reason why you would need to do that. And certainly from a defendant's perspective, think about claimant's counsel, claimant's representative. He doesn't represent the non-party. So can he, if you were to stand up and make your application in the face of the court, can he or she say anything in response? Shouldn't, because they don't represent the non-party. So you've got that quirk to bring into play as well.
Yeah, and I think also we're starting to get questions on the practicalities of this now. We'll deal with, I think, the one about solicitors and non-party costs in a little moment. But somebody's asked whether, if you have an intention to seek third-party costs, should you set that out in your precedent H? And I think the answer to that is plainly no, because any application for non-party costs is not a budgeted application. It's something which falls out with the scope of the budget. Interesting, though, to think that you might be in a position right at the outset that you think you're going to go for non-party costs. But that's...
well, there are certain areas where people do, right at the outset, think about the possibility of non-party costs, Andrew.
We're going to get there, Stephen. We're going to get there.
Don't worry about it. I'm jumping at the bit. No. Mention it in correspondence. Raise it multiple times early. Why not send it to the non-party as well, not just the party? Raise it as a little postscript at the end of the defence. There are places you can put it where the non-party can't protest that they have been ambushed at the end if you lay the groundwork for the argument, even if we're not right at the outset. at a certain point in the case. Certainly better done sooner rather than later. You will increase your prospects of success if you do that.
Yeah, and I think also in all of this, there is a balance between general approach and case-specific factors, which will all come together, but usually only come together at the end of the case. I want to just deal very briefly with the position of insurers, because non-party cost orders can be made against insurance companies. We've already spoken about the Travellers insurance case, and I have to say that if you're going to read any case law in this subject, the three cases of Deutsche Bank, Dimmock's franchise, and Travellers are probably the ones that you need to read. Stephen's already set out the facts of that, but it does illustrate the importance in that particular context when seeking non-party costs against insurers of this concept of the real party, because an insurer is always going to have a role as a subrogated party to the case, defending or bringing proceedings. But real party can require something more. And causation in that case, it's worth emphasising, was given quite a lot of consideration by at least two of the Supreme Court justices who gave decisions on the case. Before we get to credit hire, I think we could usefully just have a look at the position of directors, because this is an area which I think is expanding. And the reason it's been expanding in recent years is usually due to economic distress and the circumstances in which litigation may be fought out between corporate concerns, commercial parties. But of course, at the end of the day, the losing party may not be in a position to pay costs if insolvency becomes an issue for that litigant. So the question then is, can you go after the director personally, sidestepping the issue of limited liability to make the director personally liable? Here we do see refinements upon general principles which are area specific, because when you think about it, control and funding is often not going to be enough because it's not exceptional enough. And can I say what I mean by that? Often directors will have their own financial interests in the company, which will be difficult to disentangle from the company itself. Litigation may be in the company's interest, but at the end of the day, if the director is going to get dividends and increase the value of a shareholding, that is, again, something which flows from the company pursuing litigation for its own benefit, but the director benefits too. Similarly, a company as a legal personality can only act through its agents, which are the director. So the director has control of the litigation, but at what point does control of a company's litigation become something more than that? So the courts impose an additional requirement that there must be some distinct personal benefit or bad faith or impropriety to make a non-party costs order in a particular case against a director. And there have been quite a few authorities on this case which illustrate this approach. There's simply one we would draw to your attention, which is paper mache. Now, what I'd like to do now is hand over to Stephen to take us through the thickets of credit hire and non-party costs orders.
Well, where do we start, Andrew? Anyone looking to secure a non-party costs order in the credit hire arena really should start with Farrell and Direct Accident Management, 2009 Court of Appeal, where the form of agreement under consideration was very similar to the form of agreement that's still in use today by not just that company, but the vast majority of credit hire companies. You can go through it. It's very useful. It's the bedrock, really, for arguments on non-party costs. And what the Court of Appeal said in that case, interestingly, it was a mixed case where there were credit hire and other damages, that reading between the lines, the credit hire company were lucky that the trial judge only gave them, only ordered them to pay 80% of the costs. They could quite easily have been ordered to pay 100%, as the Court of Appeal pointed out. So it's an interesting case A, because of what it establishes, but also because it makes the point that you don't just divvy up the value of the damages claimed and award the proportion of the costs. It's a much more subtle and nuanced process than that. Now, where do we go from there? Well, the next one that you all know, I suspect, is Select Car Rentals, also known as Meehan Jones. Mr. Justice Turner, who is not a friend to credit hire companies generally, upheld non-party costs order, but interestingly in that case, said in relation to Quox that 46, that the provisions within Quox, which say, look at whether or not the litigation has been brought for the benefit of someone other than the claimant, he said effectively they don't add anything to the existing jurisdiction. You're within 46.2, you've got the same considerations as you've always had. And he looked in that case at, is the claim for the benefit of the credit hire company? The credit hire company said not. He said, well, of course it's for the benefit of the credit hire company. Claimant's going to pay over the damages. Did the credit hire company control the litigation? Yes. In that case, the control was explicit and active. They instructed solicitors, contacted the defendant's insurers, and they had, of course, the standard control clause within their credit hire agreement. But they still are only ordered to pay 60%, not 100%. Causation, interestingly, in that case, Mr. Justice Turner said, not a prerequisite for recovery of a non-party costs order in a credit hire context. You don't have to show as a defendant that the claim wouldn't have gone ahead if the credit hire company hadn't been involved. You do not have to show that there is that but-for causative link. The only principle is the immutable principle, as discussed in Deutsche Bank, that the discretion must be exercised justly. So going well for the defendants at that point. 2017, the defendants think they are on a roll. And then we have Judge Gosnell in Leeds and Judge Friedman in Newcastle. Shahzad and RSA, Judge Gosnell, On Hire and Smithson, Judge Friedman, both of which effectively turned the tide back to some extent the other way. Said defendant really needs to show that there's been some active control of the litigation. That was Judge Gosnell's view. Judge Friedman, you need to show something more than a shared commercial interest in the outcome of litigation. The defendant has to go that a bit further. And that case, interestingly, relied heavily on the decision in Travellers, where there's a lot about causation and the need to show a causative link. And it looked like then we were going to have a very high bar for securing non-party costs orders in credit hire. But as Andrew and I both know, credit hire is a pendulum, as decisions swing one way, perhaps go too far one way, and then the pendulum swings back the other way, and there is always that reverse in motion. So October 2023, we get Suarez and Anexo. Actually didn't get the non-party costs order, the defendant, but some very useful comments that defendants can use in non-party costs order applications. Basically saying, again, don't look at any single factor, don't need to show explicit causative link. They're all relevant, but at the end of the day, it's about justice. And then, of course, we moved on, March 2024, Kindertons and Murtaugh. Probably most of you who do credit hire know that one. Mr. Justice Turner again. First instance, it was a mixed case, personal injury and credit hire, dismissed, finding of fundamental dishonesty. First instance, trial judge had ordered the credit hire company to pay 80% of the costs. And on appeal, credit hire organisation do benefit financially, dealt with, given short shrift, claimant's going to pay over the damages. That's enough. Control, not a threshold test, but as I say, these factors are woolly. The more control a credit hire company has, the more likely it is that there will be a non-party costs order. Even if the credit hire company is not actively exercising its contractual right to force the claimant to cooperate, claimant has that threat there in the terms and conditions. He could be sued, strictly speaking, by the credit hire company. So there is a threat of that necessitates cooperation. It's the threat rather than the execution that gives control. Causation, rejected that. Defendants don't need to show causation. Cited a case called Total Spares and Antares, which is useful, 2006 High Court case, and made the point. These factors are all relevant, but none of them provides a threshold test. There is no threshold test. So another victory for the defendants. Amjad and UKI, High Court Appeal 2023, another mixed claim, credit hire and personal injury. Claimant failed to beat Part 36. Nice point made by Mr. Justice Ritchie. Credit hire company always benefits from the litigation, so they can't come in and throw up their hands and say, we're just a car hire company, we don't benefit from litigation. And then I think perhaps the most significant one, certainly at the moment, I don't know whether it's being appealed, Pereira. Andrew, I don't know whether you've got any insight on that. You may not be able to say.
I haven't seen an appeal, Stephen. I haven't seen anything about that. I suspect we're now, 5 months on? If there was an appeal, it would be out there on the press.
Yeah. And Pereira, I think, is another must-read. Pereira and Direct Asset Management, his Honour Judge Saunders, it's only first instance, it's June of this year. And the reason I think it's powerful is because it homes in on the business model of particular credit hire companies who specialise in seeking out impecunious hirers. Now, such companies are in a different position to an ordinary hire company because they enter their transactions with their eyes open, knowing that their customer cannot, under any circumstances, pay them because they want impecunious customers. They need impecunious customers because they want full rates and long periods. So the question it gives rise to is this. Why should a company that has a business model that relies on litigation to recover funds from third parties because of the particular cohort of hire customers that you have, why should that commercial operator be insulated from the risks of litigation that other commercial operators are exposed to? So I think that's a very strong decision. And it's also interesting in the sense that it looked at the exceptionality bar and effectively said, well, this claim is exceptional because the claim for hire was directly linked to credit. Well, all credit hire claims are. Hire was the essential catalyst for the litigation. Pretty much all credit hire claims are. And the hire claim was for the financial benefit of the credit hire organisation. So if you take that as your benchmark for exceptionality, does that not pretty much encompass every credit hire claim? So there's a lot of first instance authority out there, some high court appellate authority out there, which, remember, is binding insofar as it deals with principles rather than facts upon the county court, and there is the odd court of appeal case out there. So there's quite a bit of reading to do. But the pendulum, I think, at the moment, Andrew, has swung in favour of defendants, but that doesn't necessarily mean that it's going to stay there.
No, and I think, Stephen, just sort of chipping in my sixpence on this, I think that the pendulum could be poised to swing back. And the reason for that is to really look at some of these cases. Because if you look at, say, the select car rentals case, which I'm very fond of, because it's the only case in the English law reports where my blog was cited by the judge, you'll see there that the approach that he took, upholding the recorder, who effectively split the costs on the basis of a percentage, didn't grapple with the issue of causation. And then when one comes to the Kindertons and Murtagh case, Mr. Justice Turner was dismissive of the concept of causation because he was able to distinguish travellers' insurance and say, well, that actually only applies in relation to insurance cases of the context of that. But I don't think that follows from a fair reading of the judgments of the Supreme Court, where there are parts which are clearly distinct, the approval of the Chapman guidelines, for example, and apply only to the insurance context, but others which I think are of more general application. And whereas we know that in the wasted cost jurisdiction, it's undoubtedly the test of but-for causation, if Mr. Justice Turner is right about what he says in Kindertons, and that means in the non-party cost jurisdiction, we've got different tests of causation depending upon what type or species of non-party cost order you're seeking. And that just doesn't seem to me to be right. But the only way these issues are going to be straightened out is by a decision of the Court of Appeal, or possibly the Supreme Court, which I think an issue will come back to the end of this talk, which grapples with the issue of causation and whether Mr. Justice Turner is right in Kindertons, or whether the circuit judges in the earlier cases have got their finger on the button in terms of it. Whether we'll see such a Court of Appeal judgment in the next year or two, though, must be difficult to predict. Not least, of course, because there would be so much at stake for either side, the credit industry or the insurance industry.
You wouldn't want to be that credit hire company that appealed that one to the Court of Appeal and lost.
Well, let's just say, Stephen, that the credit hire landscape is littered with bodies of fallen soldiers in earlier appeals. So you'd have to think very carefully and have the right facts to take a case like that. The questions are still flowing, and I think we can pick up
Shall we deal with Marcus's? Marcus Davies put a question in. Thank you, Marcus, for that. Where a non-party cost order fails, does the story end there, or are old arguments of Champetier maintenance still available? I would say the story ends there. I think you would really struggle. It's after Giles and Thompson back in the 90s, frankly. I think Champetier maintenance have pretty much been a dead duck. CFAs, generally speaking, they're all, or 100 years ago, 50 years ago, would have been Champetus. But now society and Champetier maintenance are reflections of society's attitude to trafficking and litigation. I think society's moved on, Marcus. I don't think digging up those old cases is going to assist, and you're not going to get a judge interested, would be my guess.
I think that must be right. The ghosts of Champetier maintenance are being laid to rest 30 years ago. There's another question here which I thought was quite interesting, which raises the issue of litigation friends and their potential viability. And strictly speaking, of course, a litigation friend brings a claim for the claimant, but is not the claimant, or indeed defends the claim, but is not the defendant. And it seems to me that there are two issues which need to be grappled with. The first is that it's wholly different if you're bringing a claim to if you're defending a claim, because a child defending a claim must have a litigation friend, same with a protected party. It's a procedural requirement. So the notion that you could get a non-party cost order against them, I would have thought is going to be extremely difficult. With the position of litigation friends, one of the issues that I've been waiting to rear its head for the last 10 years is whether Quox extends to litigation friends or not. And that, as far as I'm aware, hasn't been addressed directly in any of the multiple authorities on litigation friends' liabilities. There is, however, a number of recent cases which go through a litigation friend's liability or potential liability for cost. And those are worth digging out if you need to to look at this on a pressing basis. Time's getting away with us, Stephen. We're at 4:45 already, so we better touch upon the two last categories of case, and then perhaps sweep up some more questions. Experts and then solicitors. Now, in relation to experts, it does actually come as a rude awakening to them that they can potentially be made subject to a non-party costs order in the way that anyone else can. And that's because, if they think about it at all, they assume that they have witness immunity for what they do in relation to litigation. But there's been a trio, or rather 3 significant decisions. Thimea, which I think was a Liverpool case 4 years ago, 2020. And then a more recent case, that of Robinson, which was dealt with at circuit judge level, and then I think went to the High Court for appeal, where effectively the expert had their chestnuts pulled out of the fire for them by Mr. Justice Sweeting. But what those cases illustrate is that if you have a cavalier expert, or someone who is in breach of their duties to the court, and the list of duties that an expert owes to the court seems to be ever growing, and the ways in which they can be breached seems ever more numerous, then potentially an expert can be made liable in relation to costs. And I think some of the factual scenarios where this can arise can be really quite stark. So there have been instances of experts who have given a report in litigation and then had to go into the witness box and then admit that they know nothing about the particular type of case, clinical negligence or otherwise, that they've been instructed in, or that they've utterly misunderstood the application of the Bolam test. So I think it's going to be rare where experts are going to be subject to non-party cost orders, but it is another route potentially for...
But it's a high bar, Andrew, isn't it?
It's a high bar.
I think it was in the Robinson appeal that the judge said it needs to be a flagrant or reckless disregard of the expert's duties to the court. So it's not enough that the expert's frankly rubbish. It's got to go far beyond that.
Yeah, and thank God for that. We say in a slightly different context. But you do have these bizarre situations from time to time where experts will come into the firing line. So let's finish on the particular...
Andrew, sorry to interrupt. This is one that we didn't discuss earlier, but it did occur to me, seeing some of the questions, that you've dealt with expert witnesses, but there is actually a Court of Appeal case on a lay witness, and that's Oracle and Vickers from 2008. Now, I don't think either of us have had to look at it for years, but it used to be trotted out quite regularly at one time. That was a case where you had a dishonest lay witness, and there was an attempt to get a non-party costs order against that witness. And what the Court of Appeal said is that, in theory, such an order is a possibility, although it would be extremely rare that the court would take that route. The proper course for any defendants out there who find themselves in this position is to sue that dishonest witness for conspiracy and seek your costs as damages, or if the claim's still ongoing, add that dishonest witness as a party and make a Part 20 claim against them. So we dealt with expert witnesses, so we should, for completeness, deal with lay witnesses. But the answer is you're looking at claiming your costs as damages rather than as non-party costs.
And again, high bar, Stephen.
Yes, absolutely.
Okay, so let's have a look then at the role of solicitors. And normally solicitors are, if they're going to be made subject to costs at all, going to be subject to the wasted cost jurisdiction. And that's another whole webinar in itself. But the non-party route can be pursued, and it should be borne in mind that the usual context in which this arises is that the solicitor and their professional indemnity insurers present a deep pocket, where otherwise there may be either Cox complications or insolvency considerations which would prevent recovery for costs. And the courts are well aware of this, so these orders are going to be necessarily rare, and the similarly high bar that would apply to a wasted costs order effectively ports across. There is, however, one case famously where a non-party costs order was made, that of Myatt and the National Coal Board. It's from 2007. It's worth reading. It goes back to the good old days of CFA enforceability challenges in circumstances where the solicitor's CFA was found to be unenforceable at first instance. They then pursue an appeal to the Court of Appeal. They lose in the Court of Appeal, and they have to pay a contribution to the costs of the successful defendant. The reason or justification for it was that in pursuing the appeal to the Court of Appeal, they were pursuing their own interest in the litigation rather than that of their clients. Having said that, there's been a string of cases over the years. Germany and Flatman is one of them, Willers and Joyce another one, PME and the Scout Association in the last year or two, where attempts to bring in solicitors for the non-party cost jurisdiction have all failed. And they fail because a solicitor is in a particularly difficult position. They bring the litigation for their client, but they're not their client. They can act under a conditional fee agreement, which gives them a financial interest in the case, but that is disregarded as a matter of policy. And so you have to show that they've stepped outside the protective boundary of the Courts and Legal Services Act of 1990 and done something more than a solicitor would ordinarily do to justify an order. Looking at it from a slightly different angle, solicitors fund litigation by deferring their fees and making them contingent on success. But that, again, is not enough to take them outside the protective band of the statute. PME and the Scout Association was an attempt to get round the Cox provisions, but it failed. And perhaps unsurprisingly, I don't think that was then pursued further to a second appeal. So we're now in the last 7 or 8 minutes, Stephen. Where would you like to go now?
Well, let's have a look. We've got a question 422. This is one we can deal with shortly. In light of what appears to be a shift away from DMX to the concept in Deutsche Bank of whether a non-party costs order is just, is it still necessary to demonstrate all of the touchstones of funding, control and benefit? The answer to that is no, but it would certainly help your application if you could. Strictly speaking, as I said before, you can put any factor before the court that you think is likely to be persuasive and likely to carry weight with the judge. You are not restricted to those key factors. You can go as far beyond them as you want. And that might tie in with another question, which is if a claimant funds a litigation through fee remission, would it be make it more difficult for the defendant to obtain non-party costs order? Well, again, isn't that just a factor going to the justice of the case? If the non-party's position was somehow connected to the claimant and the claimant's funding was relevant in a way, would that matter? The fact that the claimant can't pay you, that's certainly a factor I've used before in applying for non-party costs orders that doesn't do justice because the impecunious claimant, the classic example, it was obvious this claimant was never going to be able to pay our costs if we won. So why should the claimant have a free bet? There should be some consequences for those that have controlled, supported, and potentially would have benefited from the litigation. So that deals with two of the questions.
I would just add that what we can see in all these cases is the competing strands of public policy, one of which is access to justice and that people should be able to bring their cases. Another is that you have, for example, parallel jurisdictions like security for costs, where the fact that an individual is impecunious, there's no bar to them bringing proceedings and potentially racking up costs that they'll never pay. And so you always have multiple layers of consideration in these cases. And when you look at the case, or one of the reasons it's so interesting is that you can see different strands coming to the fore in different cases. Now, there's quite a few requests for free legal advice, Stephen, in some of these questions, and a lot of detail, actually, which has been posed in relation to some of them. But let's see if we can pick up some other points. Yeah, an interesting question as to whether if somebody takes the causation point, would it need to be leapfrogged to the Supreme Court, given that Travellers does seem to hold causation as a central limb of the test? I suspect not, because it would probably be a case of the Court of Appeal simply interpreting what Travellers actually mean, and therefore dealing with the question as to whether Mr. Justice Turner was right or not in the approach that he was taken. But that then means, of course, that it might then go to the Supreme Court, because one of the points that I think, we need to bear in mind is that although, in a sense, this whole area is a lawyer's paradise because there's lots of cases going in lots of different directions with lots of different criteria, what would be fundamentally needed, I think, is if a case went to the Supreme Court, if their lordships were prepared to use that as the opportunity to effectively consider the whole landscape of non-party costs. And I suspect that may happen in some case at some point, really for two reasons. The first is that in the Preston Petrodel case I mentioned at the beginning, they're very much aware of issues of limited liability and the tensions that that principle can create, and also aware that there's this difference in approach between the fact we have non-party costs orders, but no one's arguing for non-party damages orders. And the second is what Lord Briggs was saying in Travellers himself, where he said he deprecated. Actually, he didn't say that. I'm saying that that's what the effect of what he said was. He deprecated the approach in Deutsche Bank and said, well, some of us would actually prefer a bit more principle. And although he said that, he then went on to say Travellers was not the case in which to set out general reconsideration of principle, which would be applicable to all species of case. So it seems to me that if Travellers opens the door, then somewhere out there's another case which may yet stride through it and result in a reformulation of principle, in which case we can all start again. But
I don't think you'd have to leapfrog, Andrew. No. I think there's plenty of scope for distinguishing Travellers and trying to confine it to its particular insurance context. Whether that would then withstand an appeal to the Supreme Court is a separate question. But I certainly think the Court of Appeal would feel that there's enough wriggle room there for them to have a look at this and express a view.
I think that's right, Stephen. And I mustn't get ahead of myself on this point. But I do think that there is real scope here for a new broom, shall we say, to sweep through this area. And it may be in credit hire, but it may well not be in credit hire that this point is ultimately ventilated. Well, we're within the last 90 seconds of the seminar. Any concluding remarks, Stephen? Where would you leave people on this?
I think what I'd say is from a defendant perspective, you may as well have a go in a lot of cases. I'm surprised how few cases there are where defendants have just accepted that the claimant's not going to pay and written it off. Because I think if you give your notice, I'm obviously speaking from a credit hire context here, but if you give your prompt notice and you make it clear to the non-party that this is coming down the tracks, then they have a decision to make as to whether or not they abandon or continue the claim. And then you've got this additional point about, well, they made a commercial decision and this is their business model. They looked at it, they made a commercial decision to continue. Why should they be exempt from the consequences of that decision? So I think the scope, and we'll probably be in business with this sort of thing for a year or two yet, Andrew.
I would say a decade or more, Stephen, because
that's all we need. That's all we need, frankly, at our end of the game.
Well, when you're defending these applications to give the other side of the coin, in effect, it's like having a system of trenches that you put in front of your opponent, because you can argue about benefit, you can argue about control, you can say there's a lack of a warning, you can run the causation point, you can make all these particular points. you also start with an information deficit on the part of the applicant because they don't know what's been going on in many instances. And you can use that to your advantage and resist the making of the application. But it remains, I think, one of the more interesting areas of cost work because it's just so varied. So I think we're at 5 o'clock. You've been a wonderful audience. Thanks very much for attending. The slides with the references, the various cases that we've referenced will be sent out in the usual way. And there will be a video of this on YouTube in a few days' time. But thank you. And from me, good night.
It's good night from me.